Hello, and welcome to Give Me Credit. I am J.S. Waldo, and I am here with our credit genius, John Mackey. How are you this morning, John?
Well, as we were discussing pre-meeting here, a little cold, but otherwise I'm above ground, so it's good.
Yeah, you're inside. You're warm
Yeah,
right now.
yeah.
Good, 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 good. Did you get that? How many inches of snow did you get yet?
Well, I think we're 4 going on 8,
Yeah.
and that's gonna go through the day. The problem is the wind. It's about
Hmm.
45 miles an hour, so it's cold, but I excuse me, I want to say we get used to it, but we never do.
Yeah, you stay inside.
Yeah.
Well, John, we have a very interesting episode today. And before we get into this is going to be a collection call we're going to hear. Before we get into the insanity of this call, why don't you set the stage? What exactly was this debt, and why is it such a unique case?
Yeah. Well, it's what we call a museum quality debt. Believe it or not, it originated with Sears in 1995. The last activity on the card was 1998, and the call that we're going to review took place in 2013, 15 years after the account went cold.
Oh,
Sears had already sold the debt many years earlier. And then it bounced through who knows how many debt collectors until it landed with a company called Integral Acquisitions. Now, the case is important because it exposes something the public rarely sees, the back end games debt buyers play. When a debt is so old, it belongs in a fossil exhibit. This company openly tried to flip the legal process on its head, where basically what they told us, pay us first and then we'll give you the proof. That's real clever. It's not illegal, it's just really novel.
yeah, yeah, quite illegal. Okay, well, let's get into it. Let's give this call a listen. I can't wait.
Okay, let's see what we come up. This is a novel case. It's called Pay Me First. Let me set the stage. It involves a debt that originated with Sears back in 1995. The phone call was originated by the debt collector in 2013. The date of last activity with Sears was in 1998. The client lives in the state of Washington. What happens here is we call the debt collector and the receptionist tries to help us out. She gives us the correct information, but then feels uncomfortable with what she has stated and turns me over to speak with the compliance officer. The compliance officer is a self-assured, cocky individual who states, I just overcome objections all day long for a living, sir. So his job is not to give me the truth, but to overcome my objections. All I want is some form of validation. He will not give that to me unless the company is paid first. Now that's pretty novel. Also, please note that at first he describes the firm he works for as a law firm and then as a debt consolidation company. Most of what this gentleman states is pure BS. At the end of the conversation, I tell him I would talk to him again after the weekend. What you don't hear is the follow-up call I made. When I returned the call on the following Monday, I told the gentleman just what I thought of our previous conversation. In other words, I lifted the veil and spoke to him of the BS he had given us. Nothing further happened.
Hi, Paige. My name is John Mackey, and I guess maybe did we talk a little earlier today?
Yeah.
Okay, I've got a client. You probably got me off of a caller ID. Is that where you got me from?
Yes.
Okay. I do some budgeting work, and that's what I do is my job. And I was doing some budgeting work for Jill And
Jill.
right, I do budgeting work, and she's contracted me out to do some budgeting work for her.
Oh, what is budgeting? Like budgeting all her bills and her money?
Correct.
Okay.
So,
So I can talk to you about this then?
yes.
Yes.
Oh, just for sure, you do have her on the line. Okay.
Oh,
Yes, Paige, you can. Yes.
Oh, okay, perfect. All right, let me pull up your file. Here we go. I just left you a message on your phone just a minute ago. Okay. So this is so what questions do you have for me? Or what can I
Well, you're collecting on behalf of who?
Sears. Well, this is the original debt is Sears. Green Tree Acquisitions is our client. So yeah.
Okay.
This is originally a Sears card, and yeah, this is from 2000.
So you got it in 2000, or the debt was in 2000, or?
The debt, well, the original loan date was in 2000.
Okay.
No, that wouldn't be
And
accurate.
dates can be wrong sometimes, actually.
That may be when they sold it off.
Huh?
That may be when they sold it off.
The date, well, we've had this client since January of 2012, January 6th.
The Green Tree acceptance for acquisition?
Green Tree Acquisition, yes.
So you're collecting on behalf of them.
Yeah, I'm sorry, I can't hear you very well.
I know.
I want you guys outside.
It seems like there's some air in the, like a breeze or something.
Yeah.
That's not me because I'm sitting at my desk. And how much is the bill?
The bill right now is $7,346.23. I'm going to give you to my supervisor because she will be able to ask different questions faster and more accurately.
Okay.
Hi, Clinton Compliance Officer. Who do I have the pleasure of speaking with here?
Clinton, my name is John Mackey, and I've got Jill on the phone, and I am a budgeting person. I work with a variety of clients on budgeting skills and such, and that's when she got the call stating that this bill was due, she was calling me up, asking me how do we deal with this within the budget structure.
Jill, do we have your permission to speak
Yes.
to John?
Yes, you do.
Okay. Thank you very much. Jill gives permission to discuss with John Matthews. How can I help you folks?
Well, we're trying to find out, like I was telling Paige, is how much she owes, what this was for, just the basics, because,
Sure.
like I said, we're working on the budgeting end of it.
This is an amount owing in full of $7,346.23.
Okay.
Stems from a Sears account. It was charged off at $6,173.03. Still
Okay.
incurring interest at 10%.
And when was that Sears card from? I've seen her credit report because we work off of that, and I don't see any Sears on there.
Yeah, we didn't report on this batch portfolio. Sometimes they give me dates and sometimes they don't. Bear with me here a second. I know that she opened it quite a long time ago. It looks like she has an open date of 11/98, but the card was held in good standing. And the only thing I'm seeing is an account open date. I'm not seeing, and it says good standing for duration, which is a generic term that means that it wasn't something that the consumer opened, racked up, and defaulted, and then skipped out on it. It was more of an account that was used in a normal essence and paid on for a long time. I don't see a charge-off date or a statute trip date. but I know that we purchased the debt as part of an expiring portfolio where the legal side of our entity with these kind of accounts, the strategy is to give a quick courtesy call, scrape out any would-be payers, and the rest are legal referrals.
Okay. There's been a lot of fraud going on in this business. I'm sure you've heard
What
about.
business is that?
You're doing debt collection, right?
Well, we're a law firm and a mediation firm. It's a courtesy call. We plan to sue Jill Social Lending. This is a courtesy call to see if there is a willingness to want to settle out of court. This is a formal notice of intent in a matter naming person and property of one Jill.
Okay, so who holds? I'm trying to find out here because we're trying to figure out who to pay and all of that kind of stuff.
We purchased the debt. This company, Integral Acquisitions Management, to whom you're speaking with now, this firm owns the debt.
Okay, so you bought the debt. Okay.
Affirmative.
So because of the amount of fraud that's going on out there in the debt collection, and I'm not calling you a fraud. I'm not saying that at all.
I just overcome objections all day long for a living, sir.
What I would like is if you would send them documentation of this debt.
Give you a settlement letter if we're discussing a settlement, but if you want me to prove to Jill over the phone or through a fax machine that she owes the debt, what's going to happen is if she can cough up $7,346, I'll go ahead and request the proof to be unarchived, because when I do that, that is the final step in launching the suit, is pulling and unarchiving the proof and exporting the matter to, in this case, Clark County Municipal Court, where our attorney there, upon said hearing, after she serves, she gets 30 days to respond in writing to Clark. If she wishes there to be a hearing, she must request one in writing. Without doing so, there's a default judgment entered 30 days after the service completion. If she does, they set a court date out a month or two out. And during that time, our attorney's present. We'll serve a copy of the discovery information, which is the contract and the payment history on both Jill and a copy on the court, clerk of the court, and one for the judge. And in there it's clear and unequivocal that contract breaches occurred and that the debt is in statute. I can't make this sort of demand and indicate legal action to you over a recorded line if it's not something we actually intend to do. If I'm bluffing and you catch me, we're in big trouble. You can sue the pants off of us. So there's my poker hand.
Right,
Proving of the debt that's owed, if she can cough up $7,346 upon reception of the proof, that's probably the only way that they're going to not want to just give it to her as part of discovery in court. Because this has been beat up in collections for a long time. It's understood that a multitude of collection attempts has taken place. It's understood that Jill's been non-responsive to mailed correspondence to her residence and a multitude of phone calls. So, we're not in the business of proving to you that, that the debt's something that should be paid. It's a legal referral and a courtesy call. She wants proof and is prepared to immediately secure funds for $7,346 in one fell swoop, then I can get you the proof. It will come along with what's called a proof with demand letter that basically says, here's your proof. Please enclose $7,346. Without that, they immediately expedited into court once again. The strategy when this was that these are accounts that need to be sued and have been beat up already.
So what I'm hearing you say then is that you own the debt and you won't send her a validation of that debt. Am I correct?
Absolutely not. You put those words somewhere.
Well, that's what I'm hearing you say. That's why I'm asking for clarification.
Put those words somewhere. And what I told you is that I'm more than happy to give you the proof and validate the debt, but she needs to secure the full balance upon reception of it. There's no settlement that'll be discussed at that point, because unarchiving the proof is the last step in our process to sue. Or she can sit on her hands and wait and see, and the same exact thing will happen via process service. We have to unarchive the proof. It's all centralized in another state. We function in all states. And it costs us a little money, takes us a little time to do so. They don't like to do it until it becomes evident that it's necessary to do.
Okay.
All the work of validation has been done by prior agencies. The consumer has a clear recollection of the account. Give me a break. You're looking for a loophole?
It sounds like you're looking for a fight, and I'm not trying to fight.
No, I'm under strict orders. I hate this talk. I really do. It's not the way that I would run the business.
Well, Clinton, do you have a direct number? Because I'm going to talk with Jill and see, what she wants to do. Do you have a number that I can call you back on?
Yes, sir. Area code 425. Just, if I might add it, from our end of the table, it's very normal, and it's every consumer's right to request validation. We know that. On the primary phase, it's something that if you're a collection office, you have to do that. You can't even talk to the consumer until you do again. At this late in the phase, we're a debt buyer. We're the first party, not a third party. We'd be jammed up all day long with paper and processing, pulling proof, et cetera, et cetera. Our strategy is to sue these debts for profit. That's formal notice of intent to file suit. So we didn't plan on negotiating these down and things like that. Now we have to give her a shot to pay it. That's what this is. It's a shot to pay off the debt.
Right.
And if she doesn't want to, and that's a personal decision. We're not going to push or pull either way, but we're also not going to jump through a bunch of hoops to prove to consumers that the debt's valid, when doing that for the consumer is the same thing as doing that in a court of public record. We make more money in a court of public record, I'm sure you can appreciate. Judgments incur interest at the rate of 12% per annum in the state of Washington. It's a marital community property state, opening our doors for, if there's a spouse in the picture, two parties that we can attach to. If there's property in the picture, any bank accounts, or a working job wage, those are all our assets to attach to.
Yeah, now I'm not from that state, so I'm not totally aware of that. I've heard of that. Just a question, as a thought, being that the debt on the other side, meaning her husband, if they just got married, let's say a year or two ago, does that become inherited then?
Marital community property. I'm hazy on that because we get mixed results. I think it's when they don't respond and you say, the consumer's name, Jill on the summons, and the marital community property of is how it's named. So, yes, I would say yes. I'm not a courtroom litigant. I'm not sure how that stuff exactly unfolds. I just know the general law.
Okay, so you're not a lawyer then?
I'm not.
Okay.
Compliance officer. The legal side is where the stuff goes after we fail to collect on it.
Okay. Well, very good. I hope to get to you by Monday.
Thank you.
Thank you. Bye now.
Wow. Wow. So the first thing that pops into my head is the beginning of the call. The receptionist, she seems like she's being honest and gives you information, and then I don't know, you can kind of hear him in the background. But what did she tell you, and why did she get so nervous?
Well, I think it was the fear of telling the truth. And she probably figured out that she was somebody that just answered the phone and was the referral, but I started asking her questions, so I was kind of boxing her in a little bit. Now, she probably had minimal information, and I'm not going to castigate her. I think she was trying her best. She felt overwhelmed, and she wanted to move on. And who best than someone that lies every day? So,
Yeah, move it on to this this compliance officer. Let's go back to you now. Walk us through your first impression of this compliance officer.
Well, there are many words that come to mind: Nimrod, jerk. But he comes in cocky and overconfident and rehearsed. I mean, he's reading off her boilerplate language. And his signature line, I just overcome objections all day long for a living, sir. That sir at the end is kind of it's demeaning in a way. He wasn't being trying to be polite. He was trying to put me in my spot.
Right.
And, but that kind of tells you everything you need to know. His role was not compliance, not accuracy, not honesty. His job was to bulldoze. He even toggled between calling his company a law firm, a mediation firm, a debt consolidation company, all in one call.
Yeah, I caught that too. He did something which, I mean, we've talked about this so much, John, is the important things of demand validation of the debt. He demanded full payment before providing validation. How big of a violation is that?
It's huge. It's what I would describe as a nuclear grade FDCPA violation. It's a boom.
Yeah, that's how it felt.
Yeah. The law requires validation before any continued collection activity. What he demanded was basically pay the entire balance. Then we'll show you whether this debt was even yours. Well, if it isn't yours, you still paid the money and they're not giving it back.
No, they're not going to give it back.
It's not validation. It isn't compliance. As I've said many times before, and I'll continue to say it, the first time I talk to a debt collector that doesn't try to deceive or lie or cajole, I will let you know, because that hasn't happened. I've been in this field for 30 years. This pay me first stunt isn't just unethical. It's unprecedented. I've never heard of that.
No, I haven't either. That's extortion, basically.
Yeah. Yeah.
He claimed that they buy these old portfolios specifically to sue people. He used those words. What does that mean for the consumer?
Well, there's a variety of things here that come to mind. First of all, old portfolios probably are beyond the statute of limitations. So that's one thing to consider. It's one of the heaviest ones to consider. What they're running is a suit of profit. It's a threat. That's all they are. They buy dusty, bottom of the barrel portfolios for pennies, actually quarter of a cent, then mass threaten lawsuits, hoping that the consumer, in this case Jill, default by mistake. The bottom line, or the punchline to this case, is that you cannot sue successfully on a 15-year-old expired Sears account in Washington. Now, case in point, in Washington, the statute of limitations is 6 years. This debt was dead 6 times over.
Yeah. So it was all just a bluff, I guess. You know, and you mentioned it earlier, he kept switching titles.
Right.
Sometimes he was a law firm, sometimes it was a mediation firm, and sometimes he was a compliance officer. What does that signal about the collection industry?
It's kind of a dazzle me with brilliance or baffle me with BS. It's signals theater, pure performance. They use legal looking language and they use it to intimidate. You know, attorneys, compliance, legal referrals, mediation, formal notice, intent to sue. But once you push back, they retreat into, oh, well, we're not really litigants. They weaponize vocabulary, not the facts. It's a costume they wear to appear legitimate.
Yeah. You said earlier that this is one of the rarest tactics you've ever seen. Why? Why is that?
Well, because they're demanding full payment before validation. It goes beyond the standard lies and bluster. It's the exact opposite of the law. Flip it, 180. It's illegal, illogical, insane, even by debt buyer standards. Now, this collector treated validation like something you earn only after you hand over thousands of dollars. That's not debt collection. That's a shakedown.
Right, that's right. You know, it's funny because we've heard you on a couple of these calls now, and I always wonder, how do you stay so level-headed when a collector is behaving like this? What's your strategy?
Well, you'll notice at the beginning of the phone call, I said that I'm a budgeting person. And obviously, you know that that I help people with their budgeting, but that's not my primary focus. And so I go in there with the mindset, remember that old TV show, Columbo, where he's this stumbling, bumbling idiot?
Mm-hmm.
He just walks in and he lets them set the traps. And so I don't try to correct them on that phone call. I try to let them convince me that they know all, be all, end all, that they're the, to use a 20s term, bee's knees, you know, back 100 years ago. What I do is I just stay calm. I stay curious. I let them talk.
Mm-hmm.
My goal is to give them room to expose themselves. The more they talk, the more violations they confess. This guy is trying to impress me. And he talked himself right into a legal grave. And at the end, I said I'd call him back after the weekend, which I did do. And I pulled the curtain back. I told him who I was and told him exactly what he had done wrong. Surprisingly, or it's not, he never called again.
Yeah, you said that in the beginning of the synopsis of it. So he literally, once you called him on his BS, that's it.
Right.
He just walked away. So what's the biggest lesson here for consumers?
Okay. First thing is, and the reason why we're going through this and talking about debt collection and talking about the course that I've got coming up is because the CFPB has its teeth gone. It's not even a barking dog anymore.
Right. That'll be completely gone, I think, by January.
Yeah, well, they say they're running out of funds. Let's see what happens. But nonetheless, they certainly have diminished in size currently. First thing you have to understand is that validation comes first, not after. Before any conversation is validation.
Mm-hmm.
And what they were talking about on the phone regarding this particular debt is that it's a zombie debt. And it should never be resurrected.
Right.
Old debts legally cannot be sued upon. Have they done it? Absolutely. Portfolio management did it one time on a massive document. So they were called on. So large, small, mom and pop, huge organizations, whatever they are, they will lie, cheat, steal. Threats without paperwork are illegal. They've got to have the documentation. If they don't, bye-bye.
Yeah. Yeah, so if we don't have the CFPB, then we need consumers to know this so that they can protect themselves. That makes perfect sense.
Right.
So
And knowledge is key, JS. Knowledge is
Yeah.
key. Because when you know what the rules are, you have the greater ability to stand tall. And again, these rules always ask for validation. If they refuse to document it, never pay an old, expired, unverified debt. That's my opinion. Now the question is does the debt ever die? Yes, only upon death or bankruptcy, but it's uncollectible.
yeah, I guess that's the key to that one.
Yeah.
So you made it pretty clear with this. Collectors collapse when you stand your ground. You say it all the time. Stand up.
Right.
Don't be bullied.
Right. Right. We deal with bullies every day. But when you've got a professor or you've got two teams out there, one with total knowledge of the system or one that should, versus one that knows absolutely no rules of the game, they don't understand it. How do you deal with that? And that's what we're here to eliminate.
Yeah, let's ask a couple of the questions here, because he was using fear, basically. He kept referencing a lawsuit that could be filed. How do debt collectors, this is a perfect example of how do debt collectors weaponize the fear of a lawsuit?
People are afraid because they know that when a lawsuit happens, more than likely, the individual is not going to show up to court. When they don't, the creditor wins by default. Then that default judgment can become something that they collect on, either through taking of your taxes, tax refunds, can't get maybe student loans. There's just a variety of ways. Garnishment of wages. So they're fearful of this. And that's why I always say, we can go into it later on, but when you do get a lawsuit, and what we go over in the course is the various ways that they send out lawsuits without numbers, with numbers, meaning the court case file number. Sometimes they don't even put a court case file number because they're just testing you. They're seeing if you're going to respond to this. If you don't respond, then they go forward and file it. If you do respond, then maybe they won't file it, simply because filing costs money, and they're not going to want to invest money into something that's not going to be fruitful.
Yeah, you've said that before. You're not the lowest hanging fruit whenever you stand up and speak up for yourself.
Right.
Yeah. So another thing that I saw was, or I listened to, was he tried to talk about community property state laws.
Right.
What was he attempting to do by even bringing that up?
That if they get a judgment and she were to pass away, the judgment would then attach itself to the spouse. But that's only on debt that is incurred by both parties. In other words, during the marriage.
Right.
And there are.
Yeah, when I heard that was the first thing. Obviously, I dealt with community property states all the time, and that's pretty clear. You can't do that.
Yeah, it's typically states out west. talking about Washington, Oregon, California, I think is maybe Arizona. I'm not sure on Arizona.
It is Arizona, Nevada, New Mexico.
Yeah, it's the Western states. Why them? I don't know. But it's interesting.
Mhm.
And the problem, obviously, is that with these federal laws, the FDCPA, then you got state laws that can make it even tougher or stronger or strengthen it or change it for sure. And so a consumer doesn't know which one they're fighting. And that's
Yeah,
what we have
and
to unanswer or unarchive.
it's literally like it's another scare tactic. They're just bringing it in as another scare tactic.
Right.
So I think I just have a couple more questions for you. And one of the big ones for me is, why did you choose not to confront him during that call? Why did you wait until Monday? Because I'm like listening to the call, and in my head I just wanted to yell at him. You stupid moron.
Yeah, why did I do that? Because sometimes letting them think that they got one over on us and letting them calm down, they're going to be more. I'm going to have the upper hand the next phone call because number one, I'm making the phone call. Number two, it's a power play on my part. Now I'm going to share with them who I really am. I'm not going to do it then. I'm going to do it later. Now, in reality, I did want to talk with my client to see what she wanted to do. I wanted to give her all the information, the correct information, what they can do, what they can't do, and how she wanted to go forward. Obviously, I had my recommendations, which she took, and it benefited her for sure.
For sure. So what would you say to like another professional, like a financial counselor who encounters a call like this?
Well, the problem with a lot of financial counseling is they don't know. They assume, number one, that the debt is collectible. They don't know the ins and outs of the FDCPA. And I would teach them about that part of it for sure. It's not that difficult to understand, but there are nuances within this. And to be quite honest, I've gotten a lot of my information from an attorney that works and is a instructor on FDCPA violations here in the state of Minnesota. And so I've picked his brain on many occasions and hired him on some occasions to help with consumers when they file or go after debt collectors or credit reports or things of that nature.
Mm-hmm. So what does this case say about the importance of consumer education?
Well, it's everything. It's everything. If an individual knows what the rules are, it's much easier to stand up and to defend yourself. If I know the rules of a baseball game and someone else is playing this same game, we know what the rules are. We play on a fair, level playing field. And currently it's not that way. And the CFPB, when it was designed for that, to create a more level playing field. Not that it ever became a complete level playing field. So it's to do that. And that's what my goal is to develop this level playing field.
And part of doing that is your courses you're designing right now, which is going to be available for people to find on your Substack. And I'm going to take this time to bring that up.
Well, thank you. Yeah.
Those are going to be available very soon. And in those courses, people are going to learn how to protect themselves, how to handle calls like this, how to get the validation, demand the validation. You have so much knowledge, as we call you the credit genius for a reason. And I think those courses are going to be very, very helpful, especially since the CFPB is basically going away.
Well,
We
yeah.
we have to protect ourselves as consumers.
Yes, that's exactly right. We can't depend upon the government now. We can't depend upon the CFPB. The CFPB used to be, well, they never are the cops driving around looking for problems. That's not what they do. Okay, they're there to take on the most egregious problems that are out there. That's why these lawsuits are against Portfolio or the banks or debt collectors or whomever. That's why they exist, is to accumulate that information, that data, and then go after those people, those companies that are so egregious. And
Yeah, but what they also did though was they put these rules in writing, and that was big. That was big for the consumer because, as you've talked about, if you know your rights and you've done it yourself, you can protect yourself. You've actually had to sue because you knew your rights, and that's a big part of it. So now we have to make sure that we get this same education out to as many people as possible, and that's what you're doing. And I'm
that's
grateful
exactly
for
right.
that.
Yeah.
Yeah. So I want to take this time. We're going to close this up for the day. I hope that you enjoyed listening to this. Remember, you're not alone. This has been happening for a long time. You can subscribe to John on his Substack. You can subscribe to me on Substack. We obviously have the podcast here on Substack. Give me credit. But you don't want to miss John's courses, and you don't want to miss his articles. There's always great information in them. Also, remember, we're on YouTube, so you can, as they say, subscribe and ring that bell. We release a new episode every single week. So again, John, thank you so much for bringing your expertise to us and sharing this educational podcast. That entire call was so educational. We learned so much from you just since we've started this, that I'm sure our listeners were sitting there like calling out everything as it went. You can't do that. You can't do that. And that's the point. We want them to know they can't do that to you.
Because when you're on that phone call, you've forgotten all that information. And that's what the course goes over. How to handle these calls, how not to do it in a passive way, how not to do it in a passive aggressive way, but how to do it in an assertive way. You know, you offer enough information, but not enough to hang you.
Yeah, let them hang themselves. Well, thank you again, John, and we hope everybody has a lovely day. Again, remember, subscribe. We're here. Send us emails, ask us questions. We'll be happy to answer all of them. And you can email, just comment, whatever you want to do.
Thanks for having me. Have a good
Thanks,
day.
John. Bye, everyone.